Hello, friends. Very warm welcome to my business laws channel. It is well said, friends, that property is the bone of contention. So, therefore, friends, owner of the property should always write a will so that, after his death, the fighting and all does not take place among his sons and daughters. So, today in this video, I'm going to take up law of will. Number of headings I will take up. The various will be the points of discussion. What is the meaning of will? And then some legal terms which you should know before making a will. Whether the will should be registered or not. And if the person has to go for registration, then what is the process of registration? What documents are required at the time of registration? And then, who has the access to the will? And then frequently asked questions relating to will. So all these headings, friends, I'm going to take up. Let us start now. Meaning of will. A will is a legal declaration of the intention of the testator. Testator is the author with respect to property which she or he desires to be managed or distributed after her or his death. This person should have sound mind and he should have attained the age of 18 years. Should not be the minor person and he should be of sound mind. So every such person who has attained the age of 18 years and who is adult and who has a sound mind can write his will. So which are the various legal terms which you should know before making a will? And these terms I'm going to take up now. First one is, friends, administrator. When a person dies without a will, the legal heirs need to approach a court for the appointment of an administrator. If the estate comprises movable and immovable assets, his or her job is to administer the estate of the deceased. So, friends, this term we do require when the person has not written a will and he has died unfortunately. The second is decedent. This term is used to identify the deceased person. Coming next is estate. What is the meaning of the term estate? All the property and assets that the deceased owns. This is referred to as estate. Next is the executor. The person writing the will appoints an executor. An executor's main responsibility is to carry out the directions and requests mentioned in the will. Next one is intestate. This is when a person dies without leaving behind a valid will. There are laws governing intestacy to determine how your assets are to be distributed, which will differ from religion to religion. Then next one is testator or testatrix. The person writing the will or the owner of the asset is known as testator. That is, the author of the will is known as testator. Then beneficiary or legatee is the person or organization whom you name in your will to whom you give your assets. The beneficiary of the assets whom you have named in your will is known as beneficiary or legatee. Then next of kin is the next term. Persons related to the deceased by blood. And you all know, friends, children, parents, brothers, sisters, they are all related by blood. The next term is probate. Probate is the legal document to be obtained by the executors after the death of the author or the owner of property, giving them the authority to handle your assets. And this probate is a document which gives the authority to handle your assets. It is a method through which a will is certified under the seal of a court. It establishes and authenticates that the will was executed genuinely and it is the last will of the deceased. And now, friends, the last term is codicil. Codicil is the legal document which amends or adds to a will. For a codicil to be valid, it has to be written and executed in the same way as the will it amends. So, friends, all these terms I have explained. If you have any doubt, you can always write in the comment section. And now, friends, I'll take up many more headings. This is revocation or alteration of will. How can the will be revoked? How can the will be altered? A will is liable to be revoked or altered by the testator at any time, as long as she is competent to dispose of her property by will. A will or any part of a will, the making of which has been caused by fraud or coercion, as takes away the free agency of the testator, is void and cannot be enforced in law. In other words, friends, if the will has been caused by, making of the will has been caused by fraud or coercion, threat has been given, okay, or the main person's motive was to cheat the other person, then in that case, such will be void. And it cannot be enforced in the court of law. It becomes unenforceable. Moving ahead, now which law applies to the will? The Indian Succession Act 1925 is the codified law applicable and governing the law of succession. In case of any dispute, one has to refer to the provisions, the interpretation, and jurisprudential developments under this law. Then what is the time for writing and execution of will? A will can be written at any time during the lifetime of a person, but can be executed only after the death of the testator, that is the author of the will. A will can be changed a number of times, and there is no legal restriction on it. However, it is advisable not to make very frequent changes for several legal reasons. A will can also be withdrawn or cancelled by the testator at any time during his lifetime. So friends, all these points must be well noted. Now, what are the essential elements of will? The very important heading, which I would like to take up all the points and then explain. Well, a will need not be in the prescribed form. There's no prescribed format for will. It is a good practice to follow a certain pattern so that everything required by the law is included, making your will simpler, more solid, and difficult to contest. Your will should have the following essential elements. First one is declaration. As I've told you, friends, a person should be adult. And then, he should be a sound mind. First of all, you have to declare that you are of sound mind and you have to state that you would like to be the executor of your will. Who would like to be the executor of your will? You will have to state this also in the will. If this is not your first will, you should make a statement revoking all previous wills and codicils. So in case you have already written a will, then all such wills must be revoked, must be cancelled. Coming next one is prepare list of your assets. You must be having number of assets, maybe movable assets, immovable assets, liquid assets. Okay, then you must make a proper list of your assets. Okay, and now this list should include any property you own, the money which you have in your savings account, fixed deposits, mutual funds, cash, jewelry, bank accounts, insurance policies, vehicles, and all your furniture, fixtures, and etc. Immovable properties will include all your land, building, flat, shop, office, plot, garage, etc. So a proper list of your assets must be prepared. Now, compiling the list. You have to compile the list so that nothing is left out. We all know, friends, this compilation of the list is very time consuming and tedious. It is always best you should go through. Once you have compiled the list, everything should be included. You should go through the list 2-3 times at least, just to find out everything which you owned has been included in the list. Nothing is left out. Next one is divide or distribute your assets. List very clearly, item wise, who is to receive which assets. If you wish to give your assets to a minor, do not forget to appoint a custodian of the assets. It is important to select someone to trust as a custodian. Involve witnesses and sign the will. You have to sign your will in the presence of 2 witnesses. Your witnesses will then have to sign to certify that the will was signed in their presence. It is here the will should be dated, and you should specify the full names and addresses of your witnesses. Note, friends, your witnesses are not required to read your will. They just need to attest to the fact that you have signed in their presence. And now, friends, second last point is initial each page. After this, the date and place must also be written at the bottom of the will. Every page of the will needs to be signed by you and your witnesses. Any correction made on the will must be countersigned by you and the witnesses. And coming to the last point, friends, which is storing or keeping the will. Where should the will be stored? Make sure you store your will in a safe place. Copies, if made, should be stored separately from the original will. And another point which should be noted, friends, when you draft a will, avoid using complicated or technical legal terms. Many people like using legal terms while drafting such documents. This makes the layman very confusing. So make sure the language which you use to draft the will is simple and precise. And now, friends, I would like to talk about registration of a will. Section 17 and 18 of the Registration Act 1908 mandates registration of legal documents and instruments and provides a conclusive list. But it may be noted that the registration of a will is not compulsory. However, from a practical perspective, it is strongly advisable to get the will registered to avoid any conflict or future litigation. Because if the will is registered, then maybe that in future no conflict or future litigation will arise. But mere non-registration cannot be a reason to doubt the validity of genuineness of a will. It doesn't mean, friends, if the will is not registered, then you cannot say the will is invalid. Still, the will is valid because registration is not mandatory. Or you cannot say the will is not genuine. However, the doubt as to validity of the will would be less significant if it is registered. And the sub-registrar has certified that it was read over to the executor, who on doing so has admitted the contents as well. So friends, you should always go for registration of will. Once a will is registered, there is no scope for destruction, alteration or tampering with the document. There is no stamp duty payable on the registration, and hence no overhead or hidden costs are involved. Therefore, it is always advisable that a will should be registered. So friends, you should always go for registration of the will. Now, what is the process of registration of will? A will is drafted by an expert or advocate. A date is fixed in the sub-registrar office for the will registration. Sub-registrar is contacted and the date is fixed. Government registration fee is paid, and this government registration fee, friends, it differs or it varies from state to state, but it is very less. Then the testator, that is a person who has written the will, author of the will, along with two witnesses, go to sub-registrar office to get the will registered on the day which has been fixed. And moving ahead, friends, the fifth point is registered copy of the will can be collected after 2 weeks from the registration office. And what documents are required for registration of will? Friends, the documents are, friends, the person making the will has to personally go to the registered office with 2 passport size photographs. It means 2 passport size photographs of the author of the will, they are required. A mental certificate is required because testator must be adult and he must be of sound mind. Original signed will is required. The will which has been drafted, that is required. 2 witnesses must also be present with their 2 photographs. Photo proof of person who has made the will or who has authored the will, and photo proof of 2 witnesses. Address proof of the person who has made the will. Then PAN card and Aadhaar card of the person making the will, that is a testator, as well as of the 2 witnesses. Friends, these all documents are required, regarding registration of will. Now, who can have access to the registered will? Inspection of will is not allowed to public. It is not open to public. Only the person who has made the will, that is testator, can get a copy from the sub-registrar's office. After the death of the person, his or her family member or the executor can get a copy of the will after due verification of their identity. And now, friends, having discussed all these headings, meaning of will, then legal terms relating to will, essential elements of will, then time for drafting the will and revocation of will, registration of will, process of will, and then what documents are required for registration of will, and who has got the access to the registered will. And now, friends, some frequently asked questions I would like to cover in this video. The very first one is, friends, when can a will be challenged? A will is generally challenged by persons, legal representatives, or heirs if they are not satisfied with the shares allotted to them. The common grounds for the challenge are that the testator was not of sound mind at the time of writing the will. Hence, it is pertinent to make the will specific regarding the apportionment of property. So, friends, if we can prove that testator at the time of drafting of the will was not of sound mind, then the will can be challenged. Second question is, does testator need to make any changes to the will while updating it? While making a will, a person must revoke his earlier will. Already I have pointed out in the earlier discussion, and declare himself to be of sound mind. Declaration has to be given by him. In case he is writing to deprive any of his heirs from the property, it is better that he gives reasons for this. Why, some of the legal heirs are going to be excluded by him. He must explain the reason for this. A will can be revoked or modified by the testator during his lifetime, as many as he wishes to. Because I've told you, there's no limit here regarding modifications and all. However, it is necessary to get the alteration or modification registered if the first will was registered. Codicil is an instrument made in relation to a will, explaining, altering, or adding to its dispositions, and is deemed to be a part of will. Under the legal terms, I have already explained this term, codicil. You can refer to that for more clarification. Now coming to the third question, which is who gets assets if the owner dies without leaving a will? Practically, friends, many times we find the owner has not left the will behind. And unfortunately, one day it was his last death. If there is no will, the property will be distributed according to the personal law of the deceased. The Indian Succession Act is diverse and states different laws of inheritance for different commodities. For example, if the Hindu male passes away, if he dies unfortunately without leaving a will, the wife and the children, including the daughters, share the inheritance. Now, next question is where can the will be stored or kept? Legally, a will can be stored at any place. But 2-3 points I would like to discuss here, friends. It is always advisable to store your will at a safe and secured location where it cannot be tampered with and it can be easily found by your family members after your death. It may be kept in the safe custody of a locker with a trusted person or with professionals like bankers, solicitor, who will take necessary steps to inform the executor after your death. And another mode is various banks and financial institutions also offer custodian services for safekeeping your will. You can also avail of those services. Now coming to the last question, which is it mandatory to appoint executor in a will? How many executors should be appointed? And what are the powers of executor of will? So friends, you all know, I've already explained under the legal terms the meaning of executor. While the Indian Succession Act does not make it compulsory to appoint an executor of a will, it is not mandatory. This is one of the most important decisions of a testator. And testator is an executor is absolutely critical and should always be clearly appointed. There can be one or more executors appointed in the will, but the maximum number of executors that can apply for a grant of probate is 4. So 4 is a maximum number. It is common for will writers to recommend a minimum of 2 executors when someone is making a will, but it is still a common occurrence for only 1 executor to be appointed. So why 2 executors should be appointed, minimum of 2? Because if one executor cannot distribute the assets, is unable to distribute the assets, then another executor should be there to provide his service. This is the main reason behind this. So what are the powers of executor of will? They are, friends, managing your assets and your property until such time as they have been distributed to any of your beneficiaries. Till all your assets are distributed, okay, the executor's role will not be over. He has to supervise the distribution of your assets. He has to handle your assets inheritance as it has been laid down in your will. Validating your last will and testament if someone challenges its authenticity through probate court. Paying for any taxes, debts, or ongoing expenses related to your assets. And taxes, debts are unpaid, then he has to make the payment for all. So this is all about from my side, friends, in this video. I hope the content will be very, very useful for this. Do subscribe to my channel if you have not subscribed yet. Do press on the bell icon to get notifications of my subsequent videos. Keep smiling and stay blessed always. We will meet very soon. Okay, friends. Goodbye.